Spock, on August 1st, 2026, was the West Coast oil pipeline approved?
No, it was not approved, designated, permitted, licensed, or given a route. A notice was published in the Canada Gazette.
But the notice is not empty ceremony. It opens the statutory period that must pass before Cabinet may place the proposal inside the Building Canada Act.
And if Cabinet later lists it,
then the legal starting position changes. For covered federal authorizations, the findings required to permit the project are deemed favourable. Measures, consultation, conditions and disclosure remain, but the findings no longer begin open.
So the notice does not say yes.
It opens the last statutory space before the law can begin from yes.
Begin with the paper. What exactly entered the public record on August 1st?
The Major Projects Office published a Gazette supplement saying Cabinet may add the proposed West Coast oil pipeline to Schedule 1 of the Building Canada Act.
The proposal is substantial, 1 million barrels of crude oil a day from Bruderheim, Alberta, to a deep water port near Delta, British Columbia, up to about 1,250 kilometers of pipe, about 11 pump stations, terminals, power infrastructure, and an offshore loading facility.
But may is the first fact.
Correct. The notice did not list the project. Listing would require a separate Cabinet order made on the responsible minister's recommendation with reasons published in the Gazette.
The distinction matters because public language can compress notice, listing and approval into one word: fast track.
The addition keeps those stages apart. Walk us through the sequence.
First, the proposal is referred. Second, the 30-day notice is published. Third, the minister may recommend listing after required provincial and Indigenous consultation. Fourth, Cabinet may make a listing order and publish reasons.
Only after listing does Section 6 deem the determinations, findings, and opinions needed for covered federal authorizations to favor permitting the project.
The proponent must still supply information, pay fees, and take measures required by the relevant laws. Authorization cannot rest solely on the deeming provision. Consultation and conditions remain.
But the process no longer begins with the findings open.
That is the mechanism. A notice that appears to invite consideration sits immediately before a Cabinet choice that can turn the question from whether the findings favour the project into which conditions accompany findings already turned in its favour.
How much of the project is settled?
More than an idea, less than a filed route. The endpoints, approximate length, capacity, pump stations, terminals, and marine facility are in the record.
Trans Mountain Corporation, Alberta Petroleum Marketing Commission, and Pembina Pipeline Corporation are named as parties expected to form a new ownership entity. The federal page says the corridor would largely follow the existing Trans Mountain corridor.
And what remains open?
The precise route, land requirements, affected rights holders, terminal footprint, marine route, vessel frequency, final ownership, financing, tolls, public exposure, life cycle emissions, spill risk, and species effects.
The project page also links the proposal to advancement of the Pathways Carbon Capture Project. The Gazette notice does not state that dependency as a condition of listing. Whether it survives into an enforceable instrument is a question for the record that follows.
There are several clocks here, not one.
3 processes are running. The statute requires the Gazette notice. The notice says the federal minister will consult Alberta and British Columbia. It separately says consultation with Indigenous rights holders is underway.
And the notice invites public views by September 18th, later than the end of the minimum 30-day notice period. That disproves the shorthand that all consultation was limited to 30 days.
But it does not prove the process adequate.
No, a longer deadline can still be too compressed for communities assessing a corridor whose route is unsettled. The open questions include who was contacted, what capacity funding was available, what information was supplied, what changed, and whether accommodation followed.
The honest question is not whether consultation exists, it is what work consultation is permitted to do before the legal posture changes.
Give the strongest case for acceleration.
Canada faces trade exposure, weak productivity, and major projects that can move through overlapping processes slowly enough to make capital, labour, and public planning uncertain. A corridor near existing infrastructure may reduce disturbance compared with an entirely new route.
Diversifying oil exports can be argued as economic resilience. Deadlines, a public registry, and a named decision maker may be more accountable than drift.
The Act also preserves consultation, permits conditions and requires publication of studies, assessments, recommendations, rejected recommendations with reasons, risks, mitigation, and the ordinary process that would otherwise have applied.
All of that granted. What survives?
The question of why urgency must be implemented by deeming findings favourable before the authorisation path is complete.
A deadline disciplines delay. A favorable finding rule disciplines the answer. Those are different technologies, and only one is speed alone.
Close the file. What is this edition not?
It is not a claim that the pipeline was approved, designated, or granted a fast track on August 1st. The whole edition exists to prevent that error.
It is not a claim that assessment disappears. Required proponent measures, consultation, conditions, and disclosure duties remain, while the findings needed for covered authorizations are deemed favorable.
It makes no finding that consultation is absent, performative, or legally inadequate. It reaches no project-specific conclusion about climate harm, spills, whales, demand, financing, or the final route.
And it is not an argument that nothing should be built or that delay is virtuous. The question is narrower. Does a law sold as acceleration change only the clock, or the answer the process begins from?
Stated plainly.
The pipeline was not approved on August 1st. A possibility was printed in the Gazette. That paper is the mandatory threshold before Cabinet may place the project inside a regime where the federal findings needed to permit it are deemed favourable.
The notice does not say yes. It opens the last statutory space before the law can begin from yes.
Mechanism, not motive. That is the record. The rest is yours. Crew, not cargo. Keep the file open.